joining us today for yet again another important conversation with the Whistleblower House. And today we're discussing the legal framework and all the legal possibilities that are available to support whistleblowers in South Africa. And joining us today, we've got Dr. Louise Isparta, who is going to be taking us through the different elements of the legal support that is available. Dr. Louise Isparta is a practicing advocate as well as have completed her doctorate in whistleblowing. So, Dr. Louise, thank you for joining us today.
It's my pleasure.
Quite an important conversation, particularly there's a lot that's happening in South Africa at this point in time that is having quite a number of people asking, but what is my judicial protection if I go and I whistleblow and I speak? So essentially, when a person takes on the whistleblowing process or notices that there's unethical, illegal, immoral behavior that is going on within an institution, when is the ideal time to seek legal advice?
When you decide that you would like to blow the whistle, not after, because then it's more of a process of trying to correct what's already been done wrong. So, contrary to popular belief, the Protected Disclosures Act, which is not the only act regulating whistleblowing in South Africa, is very technical, and it's not as easy as it would seem. So you need to give the whistleblower guidance in terms of how to blow the whistle, when to blow the whistle, to whom to blow the whistle as well.
I want to bring in the Madlanga Enquiry that's currently happening, and I'd like for us to discuss this from an angle of judicial process, to acknowledging that the person who is whistleblowing in this particular state is somebody who's very much aware of how the judicial process and the law enforcement process works.
No, it's supposed to.
Or is supposed to work. What lessons are we drawing from this case?
It's too early to draw any lessons whatsoever. I think the most important fact is the fact that there is such an inquiry that needed to be established says it all. Because the fact of the matter is there is an incredible amount of corruption and interference with legal processes, and it's not just from the prosecution, it's from top to bottom. It really is. Whistleblowers have a terrible time. As soon as you've blown the whistle, you can accept that for all intents and purposes, your life will never be the same, unfortunately.
And appreciating all that sensitivity and the life-changing process that is, I would understand that there should be legal protection measures that are currently available. And I mean, the effectivity of those?
The effectivity of those, I would say, is as effective as could possibly be. However, the problem that I've had with the Protected Disclosures Act from the start is in terms of the section that provides release. It states that the whistleblower has all the protection already afforded to everyone in South Africa. So you have access to any legal process as long as the court has jurisdiction, which means getting an interim interdict, a final interdict, civil liability, criminal liability, whatever it is, you have access to that. However, the whistleblower needs to jump through 7 hoops to get the same protection that everyone has as a matter of due course already. And that's where the problem comes in, because the whistleblower has to prove that he blew the whistle correctly, did it with good faith, reasonably believed that what he was imparting was, correct and true in establishing bona fides, because he has to blow the whistle in a good faith manner, except when it's made to a legal representative, which is quite interesting.
Does that then, if you do it to a legal representative, does that cover the goodness of it?
No, you don't need good faith when you're doing it to a legal representative as such.
Then with that said, then how can an individual, is it even an individual responsibility to make sure that they are then legally protected when they decide to whistleblow?
Yes, the Act places the responsibility squarely on the whistleblower's shoulders. And that to me is one of the biggest shortcomings of the Act. I mean, you have so many judgments in South Africa unpacking so many of the requirements. And it's so technical that you cannot expect a whistleblower who is normally lower management to mid-management and lower echelons, actually, to understand the legal process when you have even the legal eagles fighting about, what the requirements actually are.
I just want to if we can just spend some time there for a bit. Do you have case studies or success stories in the past of how it was done in good faith and a particular individual received necessary protection Or do we have enough of those cases who can create a comfortable reporting and whistleblowing space for South Africans?
There is, and there are, yes, but that would depend on a knowledge database being established and any whistleblower having access to it in order to ensure that he or she actually does it correctly and at the correct time to the correct person. That unfortunately is what is required, because it is obviously very technical.
And with that, I mean, we briefly discussed earlier on the
Yes.
potential gaps and weaknesses in the legal system that currently exist.
Yes.
Can we discuss those?
Yes, we can.
Where do they sit? I mean, you spoke about a triangle earlier on where you
Mhm.
said that, a part of the problem sits with higher level management and
Yes.
CEOs, etc.
Yes.
But from a judicial perspective, can you just take us through those gaps and weaknesses?
So the gaps and weaknesses are the fact that unless it is an automatically unfair dismissal,
Okay.
so there all that the whistleblower would need to prove is that it was a dismissal. Then it stands for the employer to show that it was not an unfair dismissal. So, for example, Section 188, Big A, Sub 11, is where a whistleblower can say when he or she is on the eve of a disciplinary proceeding that this is actually because he or she blew the whistle. There, he or she still has to prove, I made a protected disclosure, I made it in good faith, it was correctly done. There are certain requirements. So it's never easy. And there are so many access points to law because the Protected Disclosure Act says you have access to all relief in all South African law that is already available.
Okay.
Except you have to prove that you're a whistleblower and that you disclosed properly.
Are we expecting any changes on that?
I would hope so. For example, what I see in practice very often is the isolation of the whistleblower. So
Okay.
a very big trend that I see at the moment, and I don't think it's at the moment, I think it's been there for longer than anticipated, is it's more sexual victimization of a whistleblower by whoever the whistle has been blown against. So the first knee-jerk reaction there is, we had an affair, I ended it, it's now this whole, burnt love affair, to take away the credibility of the whistleblower. So then would you go to the magistrate's court to get an interim interdict in terms of the Harassment Act? You have access to that, yes. But do those magistrates understand the principles of whistleblowing and the fact that, in fact, the Harassment Act says that the fact that you have access to other relief in terms of other laws does not take away the fact that you get protection in terms of the Harassment Act, protection against the Harassment Act.
Sure.
So that's the technicalities you sit with. And I mean, in a normal harassment case, it's already technical. And everyone does not necessarily agree as to what harassment is or what it isn't. If we did agree, legal practitioners would be out of a job. The fact that we never agree says that it's always technical.
I suppose, especially in an environment such as ours in South Africa, where, I mean, we've had a very sort of a variety of types of harassment over time, subtle, non-subtle.
Yes, and it's more often subtle, aimed at isolating the whistleblower and making the whistleblower seem totally as lacking with credibility. I think that's the most important part of it. So when you have a whistleblower, he or she is always isolated in the workplace.
Now, the legal advisory of it all, I think, sits at the heart of a whistleblower wanting to understand what sort of interventions and guidance could they most urgently access at a point in time.
Yes.
When they come forward.
Yes.
And what does that support look like?
The support is a long and a hard road. Unfortunately, there's no quick fix, and especially with our court roles. So even if, for example, you went to the Labour Court, you have to be very careful, because there's case law on the fact that every employee who's been dismissed sees it as urgent because he or she no longer has an income, right? So urgency's been blown. You don't have a basis of urgency, because the court's view is that you can be heard in due course with the rest of the people that have been dismissed. But then where are our dates in the Labour Court for hearings? It's a year or two in the future, if you're lucky, and there are no
with further
postponements.
postponement.
So you're sitting with a whistleblower who has lost his livelihood and his credibility and has no financial backing as to the legal proceedings of it. And that's what the employers that actually sanction whistleblowers count on, because it's not an even playing field. The employer has all the resources, money to drive all the litigation that they want, while the whistleblower, if they don't have someone like the Whistleblower House, for example, has none of those resources. He or she does not have a job. He's lost his livelihood. He probably can't find a job again because he's been marked as someone who will speak out, and it's not positive, unfortunately.
And I want us to move into the encouragement point of it, so that we've identified the difficulty in how the law is currently set out, the technicalities that make it difficult to access for certain people. But in terms of the improvement, and from your experience, you've worked with multiples of cases.
Yes.
How really can we look at the South African legal framework from a point of improvement? Which parts of it can really be improved to provide the necessary support and protection for whistleblowers?
I've thought about this very often. Okay, and we need to understand that so the Protected Disclosures Act and the Companies Act that also provides protection and NEMA, etc., it's paper. Okay, so the law does not do anything. The law sits in a cupboard. The law is when you apply the principles of it. But to me, and I've thought about protection, the government was interested in giving speedy access to relief at a greatly reduced cost to people who undergo domestic violence and harassment, sexual and otherwise. So, you have the Domestic Violence Act and then the Protection Against Harassment Act, which is you go to the clerk of the court at any magistrate's court that has one of those two courts. You fill in a form. It's then considered by a magistrate in chambers, and you get interim relief.
Okay.
Now, that's a very quick process. You're talking about a day or two, and it's preferable if you don't have legal representatives. I would like to see the same type of court at an magistrate's court level for whistleblowers, because that would give them interim relief immediately, because you have specialized magistrates who look for the hallmarks of a whistleblower. To me, that would be a win-win situation where you don't have legal advice and you don't need, lawyers at the initial stages, just to get that interim relief immediately.
Dr. Louise, you spoke about your sort of your thoughts on the inquiries earlier on. I wonder, with what you've just shared now, I want us to go back slightly to that, to say that, do we get a sense that the inquiries that we've seen happen, more especially, the one that we're looking at, where we've got a member of the force part of that, do we see them as maybe setting precedents to establish, i.e., functionality as well as capability at the magistrate's court, where we will have this going forward?
That would be wonderful. That would be absolutely wonderful. But the judicial inquiries very often end up in lots of mudslinging and thick reports that have no practical outcome. That's my greatest concern in that regard. However, I'm really hoping that this latest inquiry is going to have a very, very big impact on the landscape that whistleblowers see, because you have whistleblowers in witness protection, whether it's with the Office of Witness Protection or potentially private witness protection, because of the fact that you cannot trust the police, the prosecutors, the magistrates, and that is a sad, sad state of affairs. Because first you need the political will to protect a whistleblower. So now if a whistleblower is telling you, I cannot be protected because the judicial system is corrupt, you have a very big problem.
Absolutely. Now, with that said, we spoke about some success stories earlier on. If we go into potentially a case or an example that you can share with us where truly the legal support came through?
No.
For a South African whistleblower?
No. no such
That's
case.
painful to hear.
There's no such case where the whistleblower at the end of that case was not totally shunned and his or her life was not changed forever. And unfortunately, when you have the character of a whistleblower, and this I've also seen in my practice multiple times, is that's the person that's going to report wrongdoing, whether it's uncomfortable or not, and whether it's threatening or not. And I have a whistleblower at the moment that's been not dismissed once, but twice for being a whistleblower, and in short succession. And that person is the kind of army we need to raise. And she really struggled to get new employment again, because no one wants to employ a whistleblower, because what if we're doing something wrong and I don't
And then
know
this is
about
the
it?
person who's brave enough to go speak.
Correct. So we need to raise an army who's willing to speak out no matter the cost. That's literally what we need right now.
And on the example, for example, the person that you mentioned who, lost work, obviously they were belonging to a particular organization. If we look at what's available legally and we look at what or organizational policy versus legal requirements outside of that particular organization, is there an intersection?
Yes,
Okay.
there is. So, but the same with policy. Policy is a document in someone's cupboard. And unless there is the political will within the company or the organization to enforce that, then it's just a document in a cupboard. So it's nice to pay lip service, and we have a policy on whistleblowing. But I find that the people that actually sign off on occupational detriment on whistleblowers is always the CEO and top management. It is always. And those are the very people that are supposed to be protecting the whistleblowers. They have the most to lose, because the person speaking out is speaking out about their management, overall management of that company or organization.
Now, I want to think that when whistleblowers come forward, there are those that prefer to remain anonymous and confidential.
Yes.
What are some of the challenges that they face, that whistleblowers face when they desire anonymity as well as confidentiality?
Well, it's wonderful sending in a tip, but who is going to then investigate it, and how are they going to find the information, and where are they going to find a witness to come forward if the whistleblower, who is now anonymous, is the person who's the witness to the wrongdoing?
Does that merge to what you mentioned earlier on when we spoke about the whistleblower reporting in good faith, that it's the law currently as it stands puts the entire responsibility on the whistleblower?
Yes.
Is that a part of it?
Yes.
Sure.
But also they see what happens to whistleblowers in the newspapers, in the media, social media, everywhere. They know what happens to whistleblowers. So the most people would rather keep their life as is with a salary, much needed salary, than go through. I mean, I had a whistleblower crying a few days ago, saying that the most difficult thing he's ever had to do is sit his family down and say, look, I might lose my job now because I've done the right thing. And he was crying as a grown man. That's not easy to hear. But whistleblowers know what's coming, because no one treats whistleblowers as they should be treated in the country, unfortunately.
Absolutely. Now, are there sectors that are more vulnerable, or industries that are more vulnerable in South Africa?
No, it's across sectors. It is absolutely across sectors. I find that a lot of the whistleblowers, however, are from municipalities, local municipalities. And unfortunately, even when you approach people like the public protector to investigate what's happening there, the resources are limited. So you get a finding such as, okay, we've taken note of this. They need to declare a dispute at whichever bargaining council. So how have they assisted in the process? Not at all.
At all. Let's come back to that. Legal practitioners are at the helm of course, they are following the Constitution. This is what the Constitution says. We've identified the technical gaps that exist currently, and many gaps that exist. But how do they, in this current landscape, with the Constitution or the law that is currently available, how do they better equip themselves to support whistleblowers effectively?
That's a hard question, because being a legal practitioner within the whistleblowing space itself is very, very difficult. I know of people investigating me right now just because I am assisting a whistleblower. So you get targeted because you're assisting a whistleblower. And
Sure.
I don't mind that. So the first thing is to know that that's going to happen. You need to understand the risks. They are physical. They are the risks to your very livelihood and your life. However, how to best equip yourself is always read more. You need to understand what your whistleblower is going through. A lot of legal practitioners don't want to work with whistleblowers because they find them very obsessive.
Okay.
And you can understand that. I mean, they almost sound crazy because they obsess about the day their life came to an end.
Okay.
You need to understand that. And that's why the psychological support of a whistleblower is so important as well.
So they work hand in hand at this point in
You
time.
You have to ensure that your whistleblower has a space where he or she can speak about the effect and the devastation it's left in his or her life. So yes, they're high maintenance matters as well, but you have to have the drive, and I think the drive is to ensure that no matter what, the truth comes out. So how can legal practitioners help? You have to believe that the truth needs to come to the forefront, no matter who threatens you with what, and the whistleblower as such.
Absolutely. Now, there are corners and umbrellas of aid and support.
Yes.
And with that said, I mean, why is it so important for whistleblowers to reach out to organizations such as the Whistleblower House before they take any action? And I mean, how does that also ensure that the right support and guidance is provided?
So with, for example, the Whistleblower House, you get the legal aspect of it, the psychological, a stipend if you need it, if you've lost your job, and also security, physical security.
Okay.
So with the legal, it's to ensure that we don't need to fix or try and fix what's already been messed up, because remember, you get one shot at making a protected disclosure. And because the whistleblower needs to prove that he or she made a protected disclosure, not just a disclosure, that's very important. That is super important to get it right. That's why I would suggest when you decide to do it, speak to someone that can guide you through that process.
Sure. Dr. Louise, this has been incredibly insightful. I think a very honest conversation as well in terms of where are we in terms of the legal landscape, but more importantly, where can we go to for help and where can South Africans reach help for? So thank you so much for joining us today.
It's a pleasure. It's a pleasure.
And thank you for all the work that your team does.
We try.
Thank you.
Thank you.